Hello all, welcome to Legal Talks by Desi Qanun. I am Suyash and I am excited to have started this show. Today we will discuss another latest judicial pronouncement by the Honorable Supreme Court of India, wherein the scheme of Probation of Offenders Act 1958 has been discussed. The name of the case that we intend to discuss today is Lakhvir Singh Etc versus State of Punjab and Another. In this case, the appellant were youngsters who were around 19 to 20 years of age at the time of commission of offence under Section 397 of the Indian Penal Code. They were convicted under the said provision and sentenced to undergo rigorous imprisonment of 7 years each. Section 397 of IPC reads as under: if at the time of committing robbery or dacoity, the offender uses any deadly weapon or causes grievous hurt to any person or attempts to cause death or grievous hurt to any person, the imprisonment with which such offender shall be punished shall not be less than 7 years. Before the Honorable Supreme Court of India, it was contended by the appellants that they should be given the benefit of Probation of Offenders Act as they have already served close to half of their respective sentences. How they took this argument, why they took this argument, let us try to understand that. For that, we'll have to make an endeavor to understand the scheme of Probation of Offenders Act as was discussed by the court. The court inaugurated its reasoning by discussing that according to the statement of object and reasons of the Probation of Offenders Act, it is an act to give the benefit of release of offenders on probation of good conduct instead of sentencing them to imprisonment. Thus, the emphasis of this act is on reformation and rehabilitation of offenders as useful members of the society without subjecting them to the deleterious and negative effects of a jail life. Further, the court took recourse to the case of Ramji Misr versus State of Bihar, AIR 1963 SC 1088, wherein it was held that Section 6 of the Probation of Offenders Act provides a restriction on imprisonment of offenders who were under 21 years of age on the date of sentencing and not on the date of commission of offence. Thus, the offenders must be under 21 years of age on the date of sentencing and not on the date of commission of offence. If it wishes to imprison such persons, it shall have to call for a report from the probation officer. According to the court, since at the time of sentencing, the offenders in the present case had crossed the age of 21 years, therefore it opined that it was not possible to give them the benefit of Section 6. Thereafter, the court perused Section 4 of the Probation of Offenders Act that provides for power of the court to release certain offenders on probation of good conduct. According to Section 4, where the court, after considering the totality of circumstances of a case, thinks that an offender should be released on probation of conduct, then it may do so by imposing certain conditions such as maintenance of peace and good behavior. The court discussed the case of Ishar Das versus State of Punjab 1973 to SCC 65, wherein it was observed that the non-obstante clause in Section 4 reflects the legislative intention to have an overriding effect over other provisions of law, and Probation of Offenders Act, being a beneficial legislation, should be so construed. The court further discussed the case of CCE versus Bahubali 1979 to SCC 279. In this case, it was opined that the Probation of Offenders Act may not apply to cases wherein any special legislation has a non-obstante clause and provides for a mandatory minimum sentence. What is a non-obstante clause? It is a clause that has an overriding effect. Thus, upon perusing the case laws and legal provisions, the court came to the conclusion that the offenders have been convicted under the Indian Penal Code 1860, which is not a special legislation, and though minimum sentence is prescribed under Section 397 of IPC, yet the totality of facts and circumstances of the case have to be considered. These facts and circumstances include the fact that the offenders were 19 to 20 years of age at the time of commission of offense. They were quite young. Secondly, the offenders have already served around half of their sentences. Thirdly, the victim in the present case appears to have forgiven the offenders. The court came to this conclusion after perusing the record of the case. Fourthly, there is no adverse report against the offenders about their conduct in the jail. Therefore, considering the said circumstances, the court was of the view that the present case is a fit case wherein the benefit of probation can be extended to the appellant or the offenders in light of Section 4 and the relevant judicial pronouncements. Hence, the appellants were released with an undertaking that they shall maintain peace and good behavior for the remaining part of their sentence. I would like to conclude by stating that I completely concur with the reasoning of this judgment, as the legislative intent of Section 6 makes it clear that its benefit could be extended where the offenders are less than 21 years of age at the time of sentencing and not at the time of commission of offense. And despite this fact, the court exercised its discretion in favor of the offenders and beneficially interpreted Section 4 of the Probation of Offenders Act and gave its benefit. The purpose of any criminal justice system is to reform the offenders and not adopt a retributive approach wherein simply for the sake of sentencing, offenders are sentenced unduly or harshly. So thank you for listening to this show. I hope you enjoyed it. See you next time. Till then, stay tuned.